ever been asked to sign an NDA or considered asking someone else to sign one, but you hesitated because you weren't sure if it was really necessary? A non-disclosure agreement, or an NDA, is a powerful tool that helps you protect sensitive and proprietary information that you need to share with a third party for a limited purpose, but that you otherwise want to remain strictly confidential. But when they're overused or misused, NDAs can create unnecessary friction and even backfire. Today, I'll walk you through when an NDA is unquestionably necessary and absolutely worth pushing through any resistance from the other party about signing before you share anything confidential, and when it's overkill. And I'll give you some tips on how to decide which side of the line that you're on. To briefly review the fundamentals, an NDA is a legal contract whereby the party receiving sensitive information agrees to keep it confidential and not disclose it to others. NDAs can be unilateral, that is, only one party is disclosing sensitive information and the other party agrees to keep it confidential. But in the business context, usually NDAs are mutual, that is, both parties will be sharing information and agree to protect each other's confidentiality, even if the amount or significance of disclosure is lopsided. In any case, the goal is to protect sensitive information like trade secrets, business strategies, intellectual property, or even just the fact that you're in discussions about a potential business deal. You're protecting the types of things that you wouldn't want the general public, or even just competitors or other potential business partners, or some other subset of the population to know. And you're limiting the receiving party's ability to take the information that you shared with them for one specific and limited purpose and to exploit it in the marketplace for other purposes that don't benefit you. Let's talk about key situations in which you are almost always going to want to have a strong NDA in place before you disclose any proprietary information. If you're revealing proprietary methods, formulas, or strategies that give your business a competitive edge, an NDA is a no-brainer. By definition, trade secrets should be fiercely guarded and rarely disclosed. But there may be occasions where it's necessary to share this information with a vendor, consultant, or strategic partner. For example, if you have a dietary supplement company, you will need to share your proprietary formulas with a supplement manufacturer to actually create the capsule or powder form for distribution and sale. You don't want the manufacturer reselling your formula to another nutrition company or to make their own in-house nutraceutical product using your methods. So you'll need to have them sign an NDA or otherwise account for the confidentiality of your proprietary formula contractually. Mergers and acquisitions, or even just exploring the possibility of a business transaction, joint venture, or partnership, often require sensitive financial and operational disclosures. The purchaser is going to require in-depth disclosures from the seller during the due diligence phase, and as the seller, you want to ensure that information cannot later be used to compete against you in the event the transaction falls through. But even before you get to the diligence stage, both parties may want to ensure the general terms of the prospective purchase are kept confidential to prevent either party from seeking better offers from third parties or other market distortions. In these circumstances, even though the selling company makes more and more significant disclosures, mutual NDAs are common. Now, if you're discussing an unpatented invention or prototype with a manufacturer or investor, an NDA can prevent others from running off with your idea. For example, let's say you have a brilliant idea for a new mobile app. You have the business model, the marketing strategy, and the initial capital, but you need to contract with someone to take care of the coding and feature development. They'll need to know your idea and business model up front to determine whether it's feasible and how much it will cost, and an NDA protects you from the risk that your idea is so brilliant that they'll steal it and create the app on their own. But be aware that in the product development context, NDAs are just scratching the surface. You'll need to work out who owns the underlying technology, whether that's you, free and clear, or the developer who's merely licensing it to you for use in the app. And for that, some random NDA that you yank from the internet is not going to suffice. Now let's talk about the employees and independent contractors who work for your business. They'll have access to client lists, internal processes and methods, intellectual property, and any number of other things that the worker will need to do his job, but that could also be used to compete against you. Some businesses build confidentiality and non-disclosure provisions directly into their standard forms of employment and contractor agreements, and some companies prefer to have an entirely separate NDA, depending on business needs and the scope of the worker's role. Regardless, note that in some jurisdictions, it's imperative that you have your employees sign a general NDA or confidentiality agreement, as well as any other restrictive covenants, as part of the first day onboarding processes or otherwise prior to the official commencement of employment. Otherwise, it might not be enforceable without you paying additional consideration. Now, I've mentioned trade secrets and product development, but let's talk about vendors and client relationships more generally. You may have proprietary software, methods, internal databases, process manuals, or other forms of intellectual property that aren't protectable as trade secrets or that aren't disclosed directly in the context of a product development relationship, but that your clients or vendors will have access to as part of your business relationship. Again, the idea is that if the other party could take this information and use it to compete against you, or share it with your competitors or other third parties in a way that could be detrimental to you, you'll want to have an NDA in place. For example, some of my consultant clients who have specifically developed methods that they are providing to corporate clients for a sizable fee require that these clients agree to non-disclosure, as well as agreeing that all right in the information remains the intellectual property of the consultant. Otherwise, there's nothing to stop the corporate client from posting these messages on Reddit or YouTube or wherever and precluding the need for anyone else to hire that consultant again for that type of matter. So hopefully I've convinced you that a well-crafted NDA is a prudent choice, if not an outright business necessity, in a number of common business contexts. But some clients can go overboard with it, especially if they've invested in having a lawyer craft a custom NDA form for their business. They want to get their money's worth out of it. So let's quickly discuss a handful of common scenarios where presenting an NDA is probably overkill. So if you're just chatting with someone about a general business idea or an industry trend, asking them to sign an NDA can come across as paranoid or unprofessional. I'll admit that there's a big chunk of gray area here, so you'll need to use your discretion. But consider, even if you share an idea that is objectively amazing with someone, they're pretty unlikely to steal it, deviate from their own professional plans and goals, and try to beat you to the market. Most people simply don't have the time or energy. If you're asking your mentor or colleague to sign an NDA for every half-cocked idea that you generate, and especially if you never actually move forward with any of these proposals, you're going to start to alienate people who might otherwise give you valid business insights. At the same time, sociopaths do exist, including sociopaths in your industry who you enjoy as casual conversation partners simply because they generate a lot of insightful remarks relevant to your goals. So the risk of having your idea poached from casual chat is negligible but not null. Use your good judgment or talk to a mentor about when it is appropriate in your sector to escalate to an NDA. But handing out an NDA at a casual coffee meeting with a new business contact is almost always going to be received poorly. Now, if the information is already publicly or widely known in your industry, there's nothing to protect. You may actually see this explicitly carved out into some NDAs for avoidance of doubt. Restrictions should not extend to information that is in the public domain as long as it isn't the fault of the receiving party or information that was already known to the receiving party without restriction or information that is independently developed by the receiving party without making reference to any other confidential information. NDAs are not magic wands. Most of my videos focus heavily on laws in the United States, but if you're working with someone overseas in a jurisdiction where NDAs aren't recognized or enforcement is difficult, the document might not offer meaningful protection. Furthermore, even the most airtight document can be superseded by a judicial or regulatory authority if applicable federal, state, or local laws, regulations, court orders, or other legal or governmental proceedings require the disclosure of confidential information. The receiving party generally may then disclose it. I recommend proactively addressing these types of scenarios, for example, by including a requirement in the NDA that the receiving party provide the disclosing party with prompt written notice of any such court order, allowing the disclosing party the opportunity to object and to only disclose as much confidential information as necessary to comply with the court order and nothing more. So let's briefly synthesize all of this with some actionable steps. If you're on the fence about whether to present an NDA to someone you're dealing with, ask yourself, first, what's at risk? Would disclosure of the information, whatever it is, actually harm your business? If not, an NDA might not be necessary. Next, ask yourself whether the information you want to protect is specific, confidential, and valuable, or is it general and broad? There is no need for an NDA when the information is already in the public domain, or if it is so general as to be useless from a practical, competitive perspective. Finally, consider how the NDA is likely to be received by the other party and whether it will create barriers in the relationship. An experienced lawyer can help not just in drafting the document, but also in letting you know when is the market standard time to sign an NDA versus when it might make you look amateurish or overly suspicious. I'm a lawyer, so when in doubt, I would prefer that you err on the side of protecting your intellectual property and sensitive data, either through a thoughtfully tailored NDA or just by postponing disclosure. But either way, don't use an NDA as a substitute for trust building or professional judgment. It's a tool, not a panacea.